It's my very great pleasure to introduce this morning my dear friend and colleague on the High Court of Australia since 2020, Justice Steward. There's an old joke about accountants that there are three and only three types of accountant. There's those who can count and those who can't. At a very high level of abstraction, it might be said that there's only three types of High Court judge. First, there are those types of High Court judge who are the consequentialists. It's those whose primary focus is upon the consequences of their decisions. The consequentialists might be those aiming for conservative consequences, or they might be extremely liberal in the sense of being prepared to make large leaps in law to reach their desired consequence. Sometimes the consequentialists quite explicitly and properly acknowledge that their focus is on consequentialism, and they acknowledge their desire to shape the law consistently with their preferred policy. Justice Kirby was such a judge. He proudly espoused this methodology and sought to justify it. For the consequentialists, law is just really a branch of politics or public philosophy. There is a price to be paid for consequentialism, and that price is that a court that's comprised of like-minded consequentialists might one day be comprised of consequentialists of the opposite persuasion. Large social change by consequentialist judicial decisions can seriously demean a judicial institution if and when they're later reversed. But secondly, there are those judges who believe that the law is based on logic and principle, deducible by reason. That logic and principle must build upon the structure of precedent. Sometimes the application of that logic and principle leads to consequences that the judge finds politically undesirable, but that's the law that should be applied. Sometimes, although the demands of principle and logic outweigh the force of precedent, if the precedent hasn't been challenged, it's the judge's duty to apply it. But the judge need not be a timorous soul, bound merely to apply the law, but to do so with complete subservience. The development of the law is greatly assisted by those judges who apply the law, but nevertheless speak their truth. Justice Steward is not a consequentialist. His reasoning is being built in case after case upon rigorous logic and principle founded upon precedent. Justice Steward's a conservative in the proudest tradition, which is the conservation of precedent where precedent is unchallenged, and the overturning of precedent only where necessary and in order to achieve logical and reasoned conclusions. But His Honour is not a timorous soul. Most recently, for example, in a case called Rav Bar in the Commonwealth, Justice Steward questioned the legitimacy of the constitutional implication of freedom of political communication and the accompanying expansion of judicial power. Justice Steward applied that implication, as it was unchallenged, but did so by speaking his truth. So too, other members of the court expressed their views within the framework of precedent on other large issues. For instance, another member of the court and I disagreed on the very large issue of whether judges have the power to remove and reshape one or more of the purposes of legislation if those purposes are believed to be contrary to the Constitution. In our legal system, there is a slow, incremental development of the common law and legal rules, including the interpretation and application of the Constitution and statutes. Judges are generally like Lord Wright's Ancient Mariners. They hug the coast of precedent. But the very best of those judges are the ones who can point out the rocks. It is my great pleasure this morning to proudly introduce my friend and colleague, an ancient mariner who's very proud to point out the rocks, Justice Steward.
May I commence by expressing my great admiration and deep respect for the wonderful work of that very fine jurist, Sir Harry Gibbs. Sir Harry, known to his friends as Bill, was a true lawyer and a very true gentleman. He is simply one of my heroes. May I also acknowledge that distinguished former judge and former president of the Society, the Honourable Ian Callanan, ACKC. Australia owes you, sir, a great debt for the service you have given your country and for the tremendous example you have set for others not least myself. May I also thank the Samuel Griffith Society and its president, Mr. Alan Myers, ACKC, for inviting me to give this oration. It is a profound honour to present the oration in 2025 in the wonderful city of Perth. Finally, I'd like to thank my brother Edelman for his characteristic kindness and generosity in introducing me. He is a genuine and dear friend indeed, and I declare him yet again Australia's greatest jurist, living today. The purpose of my oration concerns the history of some of the jurisprudence in the High Court concerning the reach of judicial power. Chapter 3, as most of you would know, is the part in the Constitution which deals with judicial power and who may exercise it. Chapter 1 concerns legislative power, Chapter 2 concerns executive power. It is not my intention in this oration to define what judicial power is, although I will touch upon that topic. As you will discover, the issue of what is and what is not exclusively judicial power is a profoundly difficult issue. Indeed, in Chief Justice Alsop's 2020 Sir Harry Gibbs oration, he stated that judicial power simply cannot be defined. Rather, my intention today is to trace some of the history of the jurisprudence concerning Chapter 3 as an educative illustration of how my court develops or perhaps changes the law. The pace of that change has very rapidly increased in recent years. That is why this speech is entitled The Long March of Chapter 3 of the Constitution. Now, my aim is not to give critical commentary on what has occurred. That would not be appropriate. In that respect, I must confess that I'm sometimes perceived to be a nonconformist on the court. Whether that is accurate, I don't know. But as will become apparent, I have struggled to agree with much of what has been happening recently in relation to the court's jurisprudence in this area. It is possible that even Sir Harry may have shared my struggles. In any event, in what follows, let me simply give you some facts, some food for thought. I suspect many of these facts you may have not heard of before. The issue of what is judicial power is important because Australia embraces the doctrine of the separation of powers in its constitution. That doctrine is assumed to be beneficial, but that is a big assumption. And it is not necessarily achieved by having a constitution. In the 1970s, the British journalist Ludovic Kennedy, who incidentally helped sink the Bismarck, interviewed on TV the then Lord High Chancellor of Great Britain, the second Viscount Hailsham. He was asked if he had any conflict of interest, given that he sat in Cabinet, sat in the House of Lords on the Woolsack, and also sat as a judge in the Appellate Committee of the House of Lords. In other words, he held offices in all three branches of government. He politely said no. He said it was his very function to keep each branch of government separate, and that for this purpose he needed to be a member of each. He said that this was a better way of governing the three branches rather than leaving the task of separation to a written document, namely a constitution, such as that found in the United States. Now, in that country, its Supreme Court first recognised the immediacy of separation from the words of its constitution in a case called Hayburn in 1792. It then became entrenched. In 1931, in Victoria's stevedoring and general contracting co. and Meeks, Sir Owen Dixon well expressed Australia's adoption of this doctrine. He said, and I quote, "When they adopted the distribution of powers which they found in the Constitution of the United States, the framers of the Constitution were, of course, by no means unaware of the significance given to the distribution and of the consequences flowing from it. But an independent consideration of the provisions of the Commonwealth Constitution, unaided by any such knowledge, cannot but suggest that it was intended to confine to each of the three departments of government the exercise of power with which it is invested by the Constitution, the doing of that which can be done in virtue only of the possession of such a power." The foregoing explains foundational authorities, such as Boilermaker's case in 1956, which established that the judicial power of the Commonwealth could not be conferred on a body which also exercised non-judicial power. In that case, legislation conferring both judicial power and an arbitration power on the Commonwealth Court of Conciliation and Arbitration was held to be invalid. Ironic that so many judges go from exercise judicial power to arbitration, in any event. Dividing governmental power into three branches may be conceptually easy. It is another thing entirely to define what types of power are exercisable by each branch. In that respect, some types of power may be exercised by more than one branch. For example, both the legislative and judicial branches may prescribe the procedural rules of a court. Other types of power have been found to be exclusively reposed in one particular branch. As we shall see, that has consequences. Again, Sir Owen Dixon recognised these difficulties in the Dissent case that I just referenced. He said, and I quote, "But it is one thing to adopt and enunciate a basic rule involving a classification and distribution of powers of such an order, and it is another to face and overcome the logical difficulties of defining the power of each organ of government and the practical and political consequences of an inflexible application of their delimitation. In the first place, it was apparent that many things might be done in the course of, or ancillary to, the execution of one power, which might also be done in virtue of another." The earliest definition of judicial power in the High Court was set out in 1908 by the Chief Justice Griffith in Huddart Parker, where His Honour said this, quote, "The words judicial power mean the power which every sovereign authority must of necessity have to decide controversies between its subjects, or between itself and its subjects, whether the rights relate to life, liberty or property." Not greatly illuminating. Now, in defining judicial power thereafter in the High Court, the history of what judges did and what they did not do used to assume great, if not dispositive, importance. One used to ask, is this what judges have traditionally done? Justice Kitto made this clear in Davidson when he said that one should look to what judges did when the Constitution became law. He observed, and I quote, "Where the action to be taken is of a kind which had come by 1900 to be so consistently regarded as peculiarly appropriate for judicial performance, that it then occupied an acknowledged place in the structure of the judicial system, the conclusion, it seems to me, is inevitable that the power to take that action is within the concept of judicial power as the framers of the Constitution must be taken to have understood it." That judicial power should be defined by asking what have judges traditionally done in the past could be no surer or more obvious method of delineating judicial power from the power of the other branches. By 1970, history retained its importance. Again, Mr. Justice Kitto in the Queen Against Trade Practices Tribunal, ex parte Tasmanian Breweries, observed, quote, "It has not been found possible to frame an exhaustive definition of judicial power. But that is not to say the expression is meaningless. The uncertainties that are met will arise generally, if not always, from the fact that there is a borderland in which judicial and administrative functions overlap, so that for reasons depending upon general reasoning, analogy or history, some powers which may be appropriately be treated as administrative when conferred on an administrative functionary may just as appropriately be seen in a judicial aspect and be validly conferred upon a federal court." History teaches that judges decide controversies. That is their central role. And that includes the punishment of those who have been adjudged guilty of a crime. Neither the executive nor legislative branches can adjudge the guilt or innocence of an accused person and then, following a finding of guilt, punish that person. This was confirmed in 1992 in the famous case of Lim. It was a pivotal decision. It concerned a group of Cambodian boat people who had entered Australia illegally. They were placed in detention but then released by an order of the federal court. Whilst their case remained pending, Parliament passed a new set of provisions which were inserted into the Migration Act. These provided for the detention without warrant or arrest of aliens and for their removal from Australia. They also purported to prohibit any court from releasing an alien from custody. The Cambodians, in a case stated for the High Court, challenged the validity of these new provisions. Their senior counsel, the late and brilliant Brian Shaw QC, amongst other things argued that the provisions infringed Chapter 3 of the Constitution. The provisions constituted, he said, a bill of attainder as they in substance were directed at his clients. He also submitted that because of Chapter 3, Parliament was limited in what penalties it could impose upon a person, and the provisions, he argued, here exceeded those very limits. The validity of all the provisions were upheld, save for the section which purported to prevent a court from releasing an alien. In reaching this conclusion, the court made a number of important observations about the nature of judicial power. Justice McHugh observed, and I quote, "The line between judicial power and executive power in particular is very blurred." Note the ambiguities in it. "Prescriptively separating the three powers has proved impossible," His Honour said. "The classification of the exercise of a power as legislative, executive or judicial frequently depends upon a value judgment as to whether the particular power, having regard to the circumstances which call for its exercise, falls into one category rather than another. The application of analytical tests and descriptions does not always determine the correct classification. Historical practice plays an important, sometimes decisive part in determining whether the exercise of a particular power is legislative, executive or judicial. History, help explain by the adjudgment and punishment of criminal guilt under the law, is a power exclusively vested in the judicial branch. As Justices Brennan, Dean and Dawson said in Ling, and I quote, "There are some functions which by reason of their nature or because of historical considerations have become established as essentially and exclusively judicial in character." And they went on to identify the adjudgment and punishment of criminal guilt. Importantly in Lim, the court did not say that only judges may punish more generally, although it did make it clear that subject to known exceptions, Parliament could not validly pass a law permitting the executive arbitrarily to detain a citizen in custody for reasons divorced from the criminal justice system. That is because detention was characterised as a form of punishment which can only be imposed by a court and then only following a judgment of guilt. But it did not otherwise decide that judges have a monopoly over the exercise of any power which is punitive in nature. That the principle might have been confined in this way was confirmed by Chief Justice Gleeson in a case called Woolley. There, His Honour said, quote, "The proposition that ordinarily the involuntary detention of a citizen by the state is penal or punitive in character was not based upon the idea that all hardship or distress inflicted upon a citizen by the state constitutes a form of punishment, although colloquially that is how it may sometimes be described. Taxes are sometimes said in political rhetoric to be punitive. That is a loose use of the term. Punishment, in the sense of inflicting of involuntary hardship or detriment by the state, is not an exclusively judicial function." Close quote. More recently, in 2022, the court decided a case called Alexander versus the Minister for Home Affairs. The case concerned a challenge to a suite of provisions in the Australian Citizenship Act, which empowered the Minister to cancel a person's Australian citizenship in certain circumstances. These included where the Minister was satisfied that the person had engaged in conduct constituting foreign incursion and recruitment, these are crimes under the Criminal Code, and was also both satisfied that this conduct demonstrated that the person had repudiated their allegiance to Australia and that it would be contrary to the public interest for the person to remain an Australian citizen. Cancellation was only permitted for individuals who are dual citizens. Mr. Alexander was a dual citizen of Australia and Turkey. ASIO had assessed that he had travelled in 2013 to Syria with a Syria-based Australian member of ISIS, and that he then joined ISIS and engaged in foreign incursions and recruitment in that country. The Minister cancelled Mr. Alexander's citizenship. At that time, and at the time of hearing his case, he remained in prison in Syria. All of the judges of the court, other than myself, decided that the executive branch of government did not have the power to cancel citizenship in this way. The laws which gave that power to the executive branch were thus invalid. The basis for that decision required the court to equate the cancellation of citizenship with the detention of a person in custody. Both, it concluded, were forms of punishment. Importantly, history played, in my view, no part in that decision. No judge, for example, had ever in the past cancelled a person's citizenship. In other words, whereas history drove the reasoning in the Lim case and was the justification for the doctrine that only judges can punish a person for committing a crime, that justification here was absent. Compounding matters was the characterisation by the majority of the purpose of the citizenship cancellation power as being a form of retribution for rejecting the shared values of the Australian community. Moreover, it was reasoned the minister purported to act as a prosecutor and judge to punish breach of those criminal code provisions dealing with foreign incursion. So the principle from Lim was expanded from judges having the exclusive power to punish upon the judgment of criminal guilt, something judges have always done, to the exclusive power to punish more generally, something that they have never had in the past. This was ostensibly contrary to what Chief Justice Gleeson had observed in Woolley. Now, why did I dissent? Well, it was essentially because of history. Cancelling citizenship has never been a judicial function. It's not something that judges have done in the past. If one asks the question that Justice Kitto posed, in 1900 was the cancellation of citizenship by judges so consistently regarded as peculiarly appropriate for judicial performance, the answer would be no. For one thing, citizenship in this country did not then exist. Indeed, with great respect, the conclusion reached by some in the majority contradicted history, which for Australia commenced in 1870 with the Naturalisation Act in the UK, and following that with our own Naturalisation Act in 1903. Under those acts, it was in the executive branch that had the power to denationalise a person. Moreover, the authorities supported the proposition that the federal executive can impose, in certain circumstances, detriments and penalties based upon the fact that some crime had been committed, and the usual example given for that is the power to cancel a person's visa upon committing a criminal act where they are sentenced for more than 12 months. I was also not satisfied that the purpose of these laws was retribution. Parliament expressly stated its purpose in Section 36A of the Citizenship Act. That provision makes no reference to retribution. Rather, it states that the new provisions permit the minister to cancel citizenship when a person severs their bond with the Australian community and acts to renounce their allegiance. The finding about retribution seemed, to me at least, to contradict those words. The court's conclusion also, in my view, contradicted some prior authority. In Ex parte Walsh, Sir Isaac Isaacs referred to a man who was thought by the whole of the rest of Australia to be of so great a danger that nothing short of expulsion would be an adequate protection to the community. Sir Isaac Isaacs observed that Parliament could validly pass the law for that person's deportation, and that exercise of such a power was a matter reserved to the executive branch of government. His Honour said, quote, "There is nothing in the written constitution to require the power of deportation always to be exercised through the medium of the judiciary." I was also not satisfied that Mr. Alexander was really being punished by having his citizenship cancelled. Certainly such an outcome was nothing, in my view, equivalent to being imprisoned. Why did I think that? Well, in determining the constitutional validity of the provisions, one is required to assume that the minister here had been validly satisfied that Mr. Alexander had committed the crime of foreign incursion in Syria, and that by his conduct Mr. Alexander had repudiated his allegiance to this country. It's on those assumptions that one tested the constitutional validity of these laws. If that is so, why would it be punishment for the law simply to give effect to his act of repudiation? The cancellation of Mr. Alexander's citizenship was, for me, the de jure acknowledgement of something which de facto had already occurred, namely his rejection of the Australian body politic. A similar outcome then took place the following year in a case of Ben Breaker. Some of you may know about this man. In 2008, he'd been convicted of intentionally being a member of a terrorist organisation, of intentionally directing activities of a terrorist organisation, and of possession of a thing connected with preparation for a terrorist act, knowing of that connection. Mr. Ben Breaker was sentenced and found guilty and sentenced, and that sentence expired in 2020. But he was thereafter detained in prison pursuant to the continuing detention regime contained in Division 105A of the Criminal Code, precisely because the Supreme Court judge was at that time of the view that if released, he would be a danger to the community. In the same year, the Minister cancelled Mr Benbrika's citizenship, which he'd acquired after moving to Australia. The Minister did so pursuant to another power of cancellation contained in the Australian Citizenship Act. This power did not turn upon the Minister's satisfaction that a crime had been committed, but on the fact of actual conviction in a court. The Minister nonetheless still needed to be satisfied that this conviction demonstrated a repudiation of allegiance and that it was in the national interest to cancel the citizenship. Mr Benbrika challenged the validity of this law. All of the judges of the court, but not I, held that this law was invalid, as it had offended Chapter 3 of the Constitution. The essential point of the plurality was that cancelling Mr Benbrika's citizenship imposed further or additional punishment upon him for his past offending. Only judges could do that. And it did not matter whether there were any historical analogues of judges themselves exercising such a power. As Chief Justice Kiefel, Justices Gageler, Gleeson and Jacob observed, and I quote, "Once it is accepted that Chapter 3 of the Constitution makes imposition of punishment consequent upon a finding of criminal guilt exclusively judicial, and once it is further accepted that determination of citizenship purportedly authorised is punitive in character, the absence of any precedent for a court being empowered to order this kind of punishment is not to the point. Chapter 3 requires a punishment to be imposed by a court if it is to be imposed at all." Again, as I've already mentioned, I dissented. I could not characterise the power in question as punitive. Instead, in my view, the power reflected a fundamental proposition, namely that the key to Australian citizenship is allegiance to this country. I thus observed, and I quote, "We are not here considering the act of cancellation of citizenship in a vacuum. We are considering it in a particular context and for a particular purpose. That context is that the person in question has, by their conduct, demonstrated a repudiation of their allegiance to Australia, and cancellation is in the public interest. In those circumstances, it would be wrong to conclude that the cancellation of citizenship has harsh consequences. The person in question has, by their conduct, objectively disavowed membership of the people of the Commonwealth." I then observed that the fundamental character of the power was not cancellation because of a conviction for a crime. It was cancellation when the conviction demonstrated a repudiation of allegiance to Australia and it was in the public interest to cancel that person's citizenship. The next step in the Long March took place the following year. It is the decision in YBFZ. Now, YBFZ, if I can call him, was part of the group of detainees who had been released following the NZYQ decision. Following that release, Parliament passed the Migration Amendment (Bridging Visa Conditions) Act 2023. This introduced a series of provisions into the Migration Act and the Migration Regulations which would permit the issue of a special visa to the detainees who had been released, but in certain cases subject to certain conditions. The detainees needed to have a visa because under the Migration Act, an alien who has no visa in Australia must be detained and removed. Two of the visa conditions were what were called the monitoring condition and the curfew condition. The monitoring condition required an electronic monitoring device to be affixed to the visa holder, usually around the ankle. This permitted continuous electronic surveillance of the person's location. The curfew condition usually required the visa holder to stay within a specified location, often that person's home, overnight. The migration regulations obliged the minister to impose these conditions unless he or she was satisfied that it was not reasonably necessary for the protection of any part of the Australian community to impose one of these conditions or all of them. To assist in the application of this regime, the government established a Community Protection Board. Its function was to give advice about the application of the visa conditions for each visa holder. It developed a set of guiding principles. Amongst other things, these stated the following, quote, "When considering what level of risk an individual may pose to the Australian community and whether it is not reasonably necessary for protection of any part of the Australian community to recommend imposition of a visa condition, the board should use its skill and knowledge and experience to come to a collective view." The guidelines required the board to have regard to immigration history, criminality, behaviour in criminal custody, behaviour in compliance with visa conditions, medical and health information, security information, and so on. Consistently with the tailored nature of these new provisions and regulations, of the 153 of the new NZYQ group, I won't call them a cohort, 59 were issued visas without either the monitoring or curfew conditions, 10 were issued visas subject only to the curfew condition, and 23 were issued visas subject only to the monitoring condition. In the case of YBFZ, the board recommended that the grant of his visa be subject to both the monitoring and curfew conditions, given his extensive and continued criminal history. Certain other financial prescriptive conditions were not imposed, and the board expressly advised that his case be reviewed within 3 months. But about 15 or so other conditions were also imposed upon him, which constricted his liberty and might have been characterised as harmful, but about which he made no complaint. For example, one of the conditions was that the plaintiff, YBFZ, needed to obtain the minister's approval before taking up employment in a number of occupations, such as, for example, those that involve the use of or access to chemicals of security concern. YBFZ challenged the validity of the regulations which imposed the monitoring and curfew conditions on the ground that each infringed Chapter 3 of the Constitution. Each imposed, it was argued, a form of punishment reserved exclusively to the judicial branch of government. Save for myself and Justice Beech-Jones, all of the judges of the court agreed with YBFZ, although my brother Edelman's reasons differed very much from that of the plurality. The regulations were thus held to be invalid. The lead judgment was given by Chief Justice Gageler, Justices Gordon, Gleeson and Jago. In it, the meaning of judicial power was finally divorced from any necessary connection with history and traditional judicial practice in favour of what appeared to me, and I said this in my judgment, very abstract concepts. And it was made clear that only judges can apply and enforce laws characterised as punitive. But what was punitive was expanded. This was said to be, quote, an evolution, close quote, of the law. What was punitive was now to be founded in the following new principle that there exists, and I quote from the plurality's judgment, a broader stream of common law and constitutional principle based upon the preeminent value the law of this country gives to the protection of human life, bracket from arbitrary capital punishment, close bracket, limb, comma, now called bodily integrity, bracket from arbitrary corporal punishment, bracket, and liberty, bracket from arbitrary detention, full stop. This reflects the common law's acceptance of the inherent and irreducible status of each human being in the compact between the individual and the state, a compact which this country inherited and within which the Constitution was enacted. The source of authority for the foregoing was said to be the 17th edition of Blackstone's Commentaries. For my part, I was not aware of this constitutional compact before in this country. Moreover, their honours made it clear that judicial power is not frozen in time, but instead exhibits characteristics which are, quote, deeply rooted in a tradition within which judicial protection of individual liberty against legislative or executive incursion has been a core value, close quote. For this proposition, the majority referenced a single High Court judgment. It was a dissenting opinion of Chief Justice Gageler. Uncoupling the meaning of judicial power from history permitted the court for the first time that as a matter of federal law to say only judges may impose a curfew and only judges may exclusively require the wearing of monitoring devices. Relevantly, judges have never before exercised a power of curfew and have never decided that judges have the exclusive power to impose a monitoring device. Their Honours nonetheless went on to explain that there was no freestanding constitutional right to protection from all interferences with bodily integrity or liberty. This was a change in the concept of a judicial judge-imposed punishment for the committing of crime to a free-ranging concept of that which is punitive. They said, and I quote, there are many interferences with bodily integrity and liberty authorised by the legislature, both significant and insignificant, which are non-punitive and therefore do not infringe on exclusively judicial power, close quote. However, we are not told precisely how and when we are to characterise a law which interferes with bodily integrity and or liberty as being non-punitive. Yet note how many laws may be characterised as an interference with your liberty. Instead, we now have a brand new two-stage test. Stage one involves asking whether a law is prima facie punitive. This is to be determined in the following way, and I quote from the plurality. In the constitutional context, the prima facie character of a power may be punitive by default, bracket, for example, a power to impose involuntary detention, close bracket. If not punitive by default, the task of characterisation of the power begins by determining the meaning and scope of the law's practical and legal operation, and the end or object the law is designed to achieve, bracket, ascertained objectively from its whole text and context at a level of generality or specificity, calibrated to the importance of the constitutional value at stake, close bracket. The object of the required analysis is ultimately a single question of characterisation, whether the power to impose the detriment conferred by the law is properly characterised as punitive and therefore as exclusively judicial. I'm sure that was very helpful. Perhaps compounding matters is that recently in Cherry, the Court unanimously endorsed the following proposition from Justice Gageler's earlier judgment in Minogue, quote, deprivation of liberty consequent upon a determination of criminal guilt is without more an exercise of judicial power. Punishment in the generic sense of stated infliction of involuntary hardship or detriment is not. So that's the first stage of the test. Then something new is added to the meaning of judicial power. It's the second stage. It is the doctrine of judicial justification, which you apply if at the first stage you decide that the law is prima facie punitive. Their honours in the plurality reasoned as follows, quote, justification involves asking if the power having a prima facie punitive character is reasonably capable of being seen to be necessary, bracket, in the relevant sense of reasonably appropriate and adopted rather than essential or indispensable, close bracket, for a legitimate and non-punitive purpose, in which event the power's constitutional character is then non-punitive. No precedent was cited for that proposition. My brother Edelman's reasons are noteworthy. His Honour did not consent, but he adopted a very different form of analysis, which, when you read it, and I urge you all to read it, you may prefer. He commenced with an orthodox and very helpful description of what is classically considered to be punishment. He adopted it from Professor Hart's famous work called Punishment and Responsibility, Essays in the Philosophy of Law. Justice Edelman said, and I quote, in a description to which this court has referred to on numerous occasions, Professor Hart famously described the standard or central case of punishment as involving the following elements. 1, pain or unpleasant consequences. 2, for an offence against legal rules. 3, of an actual or supposed offender for their offence. 4, intentionally administered by humans other than the offender. And 5, imposed and administered by an authority constituted by a legal system against which the offence is committed. As Professor Hart recognised, his description was only of the standard or central case of punishment. He said that his description was not exhaustive or definitional. Justice Edelman decided the applicable migration provisions and regulations were invalid, but not because of the doctrine of the separation of powers. Rather, they were invalid because they went beyond the reach of the alien's power conferred by Section 51(29) of the Constitution. 19 of the Constitution. A law which, for example, authorised the detention of an alien beyond what is reasonably capable of being seen as necessary for the purposes of deportation would not fall within the ambit of the alien's power. That, with great respect, is very orthodox reasoning. Such a law would be invalid whether exercised by the judicial branch or by the executive branch. Justice Edelman concluded that the monitoring and curfew conditions were extreme and disproportionate impositions or constraints that went beyond the alien's power. Now, as I mentioned already, I dissented, of course. I said the following. More recently, the limb principle has been extended. The extension is manifest in the reasons of the majority, which, amongst other things, seeks support from dissenting reasons in recent cases of this court. From preserving to a court, and only to a court, a function which is clearly and exclusively judicial, the principle has, with respect, been used to strike down laws passed validly by Parliament concerning matters which have not ever, historically or otherwise, been the exclusive preserve of the courts. Upon reflection, it is now clear that the limb principle has slipped away, indeed has become entirely uncoupled from established and basal principle as implied from the structure of the Constitution. I referenced an opinion of Mr. Justice Frankfurter, a famous Justice of the Supreme Court of the United States and a dear friend of Sir Owen Dixon, as to what types of punishment are exclusively proposed in the judicial branch. Frankfurter J. said in the United States against Lovett, quote, "Punishment presupposes an offence, not necessarily an act previously declared criminal, but an act for which retribution is exacted. The fact that harm is inflicted by governmental authority does not make it punishment." I then went on to warn expressly that there's a real danger in reasoning from, and I quote myself, highly generalised, undefined and abstract concepts, or perhaps aspirations, which will inevitably mean very different things to very different people and judges. I then said, a difficulty with this new expression of the limb principle, if it may be still called the limb principle, is its potential, as observed by the Solicitor General of the Commonwealth, to introduce incrementally into our Constitution a judge-made form of a Bill of Rights, whenever a law of the Commonwealth in some way relevantly harms or infringes upon the liberty of a person. With each such increment, the executive branch will be denied more and more power. That is because such a law, if it is to be valid and pass muster, must on this view satisfy the opinion of the judiciary that it pursues a, quote, legitimate and non-punitive purpose, a concept which has yet to be clearly defined. This expression of principle does not, as it should, properly inquire into what, having regard to history, may correctly be seen as exclusively judicial functions. Instead, there is now a seemingly free-ranging investigation into whether a law is punitive or harmful, and if so, whether it can otherwise be justified in some way as legitimate without a delineation of the principles or values by which this judicial conclusion is to be reached, close quote. I also referenced Frankfurter well-known warning, courts should not enter this political thicket. I went on to decide that the contention that as a matter of federal law only judges can impose curfews and ankle bracelet monitoring devices was unsupported by history and precedent. Strikingly, this very dramatic change in constitutional law was not the subject of any commentary in the media. It emerged without a sound. More recently in Ravbar, which my brother Edelman referred to, he in that case himself expressed concerns about the new Chapter 3 doctrine. Ravbar was a case in which certain members of the CFMEU sought to challenge the validity of the law which appointed Mr Mark Irving, KC, as administrator of the CFMEU for up to 5 years. The challenge relied upon, amongst other things, both the doctrine of the implied freedom of political communication and a submission that the law infringed Chapter 3 of the Constitution. Only judges, it was submitted, can appoint an administrator to a union under a federal law. Justice Edelman said this about the current two-stage test, if I may quote you. As a matter of precedent, unless there were compelling reasons to depart from it, I should endeavour to make the best sense of and to apply the test supported by a majority of this court in YBF said, for whether legislative means are punishment. But with great respect, the state of the present jurisprudence concerning the concept of punishment in Chapter 3 of the Constitution is extremely difficult to understand or apply and involves a legal fiction. The test is essentially that a legislative means is punitive if it is prima facie punitive, unless a court concludes that it is not punitive because it is not for a punitive purpose. To sum up, the new state of the law is as follows. To determine the constitutional validity of any given federal act of Parliament which confers a power on the executive branch of government, you first must decide whether the means mandated by the Act are prima facie punitive. If so, then at the second stage, those means will be actually punitive unless they are reasonably capable of being seen to be necessary in the sense of being reasonably appropriate and adopted for a legitimate and non-punitive purpose. This new test is doing more than mere knitting. In conclusion, whether this long march of Chapter 3 is at an end, I cannot say. But finished or not, part of me does think that there is something in that alternative method of keeping the branches of government separate, as proclaimed by Viscount Hailsham. But I suspect that to make that option work, you would need a Viscount Hailsham. Thank you all for listening to me today, and may God bless you all.
It is my privilege and a great honour to thank Justice Steward on behalf of all of us here today for giving the 15th Sir Harry Gibbs oration. Listening to the oration, I felt how weak and fruitless must be any word of mine should I attempt any commentary on the oration, save to say that the quality of the work speaks for itself, as does the entire body of His Honour's work. I'm sure everyone here is aware that Justice Steward was recently appointed a companion in the Order of Australia and would wish that I congratulate him on this occasion upon his most worthy appointment and thank him for his selfless devotion to the service of the Commonwealth of Australia and its people. Justice Steward is one of those very rare men whose intellectual capacity and expansive intellectual curiosity is contoured by spirituality and moral clarity. It is that combination which enables such rare men to truly devote themselves to the service of others in the pursuit of higher goals. His Honour serves the people of Australia with grace and humility. Indeed, His Honour would have made an excellent priest were he not a judge. A modern-day Talleyrand, but without the wily cynicism. It is not a small thing that His Honour possesses that spiritual and moral clarity, for to be a true priest requires a love of humanity for all it entails in equal measure, for its richness and its failings. In my opinion, it is His Honour's spiritual and moral strength which informs his jurisprudence, which gives him the courage and the humility to write the judgments that he does and to say the things he has said here today. There is nothing faux or performative in His Honour's work or in His Honour's humble adherence to established principles and to the teachings of history. When Golda Meir famously said, "Don't be so humble, you're not that important," she was not referring to His Honour. In His Honour's jurisprudence, he looks at the development of doctrine with the wisdom of history in mind through the ages of ages, and with a deep recognition of the lessons to be learned from it and the advantages of adopting a methodology which is tested incrementally over time. There is surely something inverted, even topsy-turvy, when one considers that His Honour was in a minority of one in Alexander, while contending for no more than the application of orthodox legal method. In recent times, it seems that those who espouse orthodox legal method are the new great dissenters, the new disruptors. We are fortunate to have heard His Honour's oration, which in my view exposes the unwisdom of jettisoning learnings of history and orthodox legal method in favour of a new species of assertive power, which is inherently reckless, as it proceeds from the premise that some judges in this fleeting moment in time know what is best for all of us. Please join me in showing our appreciation for His Honour's excellent and timely delivery.